Hi, my name's Diana. I work under a company called Anytime Real Estate Services, but I work with various attorneys doing real estate closings as well as other aspects of law. Some of the attorneys I work with do litigation, some do land trusts. Real estate closings is my primary focus, but can assist in many other aspects. And today I'm just going to touch briefly on one thing that comes up and seems to be a stumbling block for many of us, and that's Firpta, meaning the withholdings that are required under certain circumstances for real estate transactions that occur. And that would be primarily when it's a foreign individual who is selling. It may also be a foreign party who's behind an entity that was registered here in the United States. And we do bump heads sometimes with other offices who don't realize the importance of going behind the actual entity itself. First and foremost, if it's a person and they do not have an ID number for the United States, meaning an ITIN number or a Social Security number, we must, under the IRS guidelines, withhold 15%, which is the new rule which was passed early February of 2016. And they have an option of applying for an ID number. They can try to do that prior to the closing taking place. And we can then, once proof is provided to us that the paperwork has been sent in by their CPA, we can withhold that 15% and keep it in our trust account. This would hold true for any closing entity, meaning any other title company or attorney. They can hold it in their own trust account rather than sending it into the IRS. If, however, that party does not wish to go and apply for their ITIN or Social Security number prior to the closing taking place, then we must withhold the 15% and we will create the various forms that are required, and we send that in to the IRS, and we will retain that information on hand so at some future point when they wish to file a return and get an ID number, we can provide that to their CPA at that time. The same holds true with an entity. A lot of people today are forming LLCs, and the LLC is the tricky one, because if there's only one manager up front, we need to see the operating agreement. We need to know who exactly is behind this entity. If it's just one person, the IRS considers that something called a disregarded entity. Basically what that means is it passes right through to the individual. So we are required again to follow the same steps I've just outlined for you as though it were just the person. Now, if there are two parties named in the operating agreement, meaning two members or two managers, then we can sidestep the requirements as long as all that evidence is provided to us. The exclusion to this rule would be when certain parties sell property and they are selling it to another individual who will be residing on the property for a minimum of 50% of the time over a 24-month period. There is a form for that. It's an IRS certification that the buyer will sign. And that buyer will take the responsibility and allow the seller not to have a withholding done. Again, the requirement is that it be under $300,000, and the buyer must be willing to sign this affidavit, which would be retained in our files in case the IRS steps forward and has questions in the future about the sale. So those are the basics under the Firpta guidelines. And these things do get a little complicated sometimes. What we try to suggest is that the selling side, if they don't understand these rules, they don't have to rely upon me or our side of the closing. We suggest they contact a CPA who either handles their own internal work or the CPA for the company or individual they're dealing with. And we want everybody to be fully educated in this area. We want to avoid a problem for all of us because the IRS, as you know, has very strict rules, and we don't want somebody to be punished, which would entail penalties and perhaps other fines. And that would be a lot worse than just withholding the money for a short period of time and allowing the selling party to get it back or a portion of it back based on the IRS determination letter down the road. There are many other aspects that could pop up. I'm not a CPA, I'm not an accountant, and I'm of course available. If anybody needs to speak to me, I can point them to somebody who is licensed in those areas that can answer some of their questions. So for Firpta purposes, I think that pretty much covers it. With closings in our office, I work a lot with Grand Realty agents. I sit next door to Grand Realty, and I can be reached anytime. That's the nature of my company name. And I can also be emailed at reanytime@yahoo.com. Should you have questions, if I can help you with anything, the agents here at Grand Realty should know, and if they don't, hopefully this will inform them. I'm available to them literally almost any time. So if you have questions and you need answers or guidance, if I'm not an attorney, I am a paralegal, but I will be happy to at least point you in the right direction so you can get a more formalized answer to your concerns and see if I can help you in any way. Thank you very much.